Assalamu alaikum and welcome you all students. And this is the 15th lecture and 15th week of our course. And this is the concluding class and last topic of our course. The journey which we have started since the beginning of the journey in order to understand this course, that is the international criminal law. We have discussed various topics and a lot of uh, principles, theories, and as much as the topics, we tried our level best in order to understand the whole mechanism of the international criminal law. The topic which we are going to discuss today is without discussing, without knowing this topic, our course is incomplete. The all and the things which we have discussed, which we have learned in previous lectures, which actually regarding the how international criminality, liability, what are the factors which determine the liability on the shoulders of the individual or state in order to prosecute, investigate the international criminal law. But the certain things, certain facts which actually cover give the protection and defenses in order to protect a person itself from the investigation and prosecution of the international criminal law, that is the defenses and immunities. So in this lecture we are going to discuss and learn what are those defenses and immunities which cover or which protect the person from the international criminal liability. So students, before understanding the immunities, so the first session will consist of the topics which cover the things regarding the topics which we are going to discuss regarding the defenses, which also discuss in the ICC Statute or in the terminology of the International Criminal Code Statute grounds for the excluding criminal responsibility. The jurisprudence from the international criminal tribunals on the matter is sparse and not always satisfactory. There are numbers of the reasons for this, one of which also at least partially explain the relative lack of the scholarly attention given to the most defenses in international criminal law. This is the tendency towards a lack of sympathy for defendants in international criminal proceedings. As one of the scholars said, there are certain psychological reservation towards the defenses. By providing perpetrators of the brutal crimes against humanity with the defenses for their offenses, we have effectively lent them a hand in the findings grounds of the excluding punishability and responsibility. Other reasons include the fact that international tribunals, the prosecutor's choice of the defendants rarely includes those who have plausible claims of the defenses recognized by the law. The ICC Statute is the first treaty or similar instrument which attempts systematically to address the subject of defenses in international criminal law. Previously, substantive defenses have been developed preliminarily through the case law of the various courts and tribunals. In general, It is accepted that defenses form a part of the general principle of the criminal law, which the ad hoc tribunal must take into account in deciding the cases before them. As per the Article 31 of the ICC Statute, expressly provides for the exclusion of the criminal responsibility on the basis of mental capacity, intoxication, defense of the self or another, or certain property endures. The ICC Statute makes a residual provision for the incorporation of other defenses from the international law in accordance with the mechanism in Article 21 of the ICC Statute, Rule 80 of the ICC Rules and of Procedures, and evidence require the defense to give notice if it wishes to rely on such a defense and submit to a hearing to determine the admissibility of the proposed doctrine. In addition, Article 33 of the ICC Statute provides for limited defense of the superior orders, a doctrine which straddles the line between an excuse and a challenge to proof based upon the mistake of law. Each of these defenses is considered in turn, namely mental incapacity, intoxication, defense of the self or another certain properties, Dios means necessity, and superior orders. In addition, consideration will be given to noticeable defenses which may exist in the customary law but do not receive express consideration in the ICC statute, that are the military necessity and to coqui and repicels. These are the terminologies, these are the Latin words. Um, which are appearing on the screen. You can pronounce yourself. So students, similarly in domestic law, we are very aware that the certain general exceptions, the chapter of the general exception, the sections start from 78 to 106 regarding the defenses regarding the criminal responsibility which cannot be assigned when any act which is committed due to mistake of fact or mistake of law, or in order to commit any prohibited act in order to protect others' life or itself, your own life or properties of the others or own property. So person commits certain of prohibited acts but which are not offense. Similarly, same terminology, same things, same principles applied here in the international criminal law. The types of the defenses. At the outset, certain terminological and conceptual matters are to be clarified. In the common law world or domestic law, it is usual to speak of the defenses in the omnibus sense, whereas in civil law jurisprudence, a firm distinction is drawn between types of defenses, in a particular between justification and excuses. Justification, broadly speaking, are pleas that the conduct of the accused was acceptable and therefore necessarily lawful. It is difficult, for example, to argue that a person acting in self-defense has done anything which the law seeks to prevent. As earlier I said, there are certain domestic laws which give the cover up or which give the protection of those acts which are actually prohibited, which are actually law seeks to prevent. But in anything which is done in the self-defense or protection of the property or justification has been provided, the actually we call it excuses, painting again with the something of the broad brush, to not seek to defend the conduct of the accused per se, but seek to say that in the particular instance, the defendant ought not to be blamed for what he or she did. The boundary between the different type of the offenses is not especially clear. However, even though the classification does have important consequences, at least in a national law, domestic law, for example, there may be no secondary liability for aiding or abetting or justified conduct. The same will not be the case for excused conduct. Also, justification tend to exclude liability for the conduct in private law, whereas excuses do not necessarily do so. It is not clear that there was an agreement on the jurisdiction at Rome. Hence, the natural terminology of the ICC Statute. Grounds for excluding criminal responsibility rather than defense's justification or excuse. The distinction remains therefore useful for understanding the appropriate ambit of the some defenses. The type 1 of the defense, that is the mental disease or defect. Mental disease or defect, together with the intoxication, which we will discuss later on, exclude criminal responsibility of the individual if he or she is not able to control or assess his or her conduct. With regard to the mental disease or defect, Article 31, paragraph 1, clause A of the ICC statute states that individual responsibility is preclude when the person suffers from a mental disease or defect that destroys that person's capacity to appreciate the unlawfulness or illegal nature of his or her conduct, or capacity to control his or her conduct to conform to the requirement of. So this provision is more or less straightforward. It provides for a range of circumstances when the mental capacity of the accused is by virtue of disease defect by natural means destroyed. This is a high standard. It is not clear whether or previous neurological injury or sufficient gravity might be considered to fall within this provision. By analogy, there are cogent reasons to consider mental incapacity a challenge to prove rather than a proper defense. However, although some mental disease or defects may render the accused so delusional that they cannot appreciate the substance of their acts at all, other pathologies may do otherwise and may exert an influence more akin to intoxication. In this latter context, it may not be correct to say that accused formed no intent. Rather, it is the case that the criminal nature of their conduct is nevertheless excused by virtue of their illness. The scope of or type of this defense of the mental incapacity has not received extensive consideration before the ad hoc tribunal. The ISTY Appeals Chamber in Delalik has established that it is a complete defense which may lead to acquittal if the accused successfully proves that at the time of the offense he was laboring under such a defect of reason from disease of the mind is not to know the nature and quality of his act, or if he did know it, that they did not know that what was doing was wrong.